Good afternoon. I'd like to welcome everybody to today's webinar on small business and consumer bankruptcies. I'm Blake Hogan, CEO of AIS and AIS Law. We're thrilled to have such a large group join us today. We have 153 people registered for today's webinar. Hosting today's webinar will be John McMickle. John is co-founder of North-South Government Strategies, which is a Washington, D.C. based consulting firm. He served as counsel to the Senate Judiciary Committee, where he advised Chairman Grassley on an array of policy matters under the committee's jurisdiction, including the last comprehensive rewrite of the nation's bankruptcy laws. Joining John will be Cheryl Skiggin. Cheryl is a partner at AIS Law with 20 plus years of bankruptcy and litigation management experience. She has been a member of the bankruptcy mediation panel since its inception, and she is licensed to practice in all state and federal courts with admissions in California, Nevada, District of Columbia, England, and Wales. As I mentioned, we have a large number of attendees on the webinar, most of which are working remotely. That being said, we have elected to keep everyone on mute in an effort to enhance the listening experience. However, this is meant to be interactive, so you can share your questions by clicking on the Q&A feature or the chat function at the bottom of your screen. We'll do our best to address as many questions as possible at the end of the discussion. After the webinar, the team will review all unanswered questions and circulate the responses. Today's webinar is being recorded, so a link will be available after the webinar. We'll also distribute the slides. With that, I'll go ahead and turn it over to John and Cheryl. Thank you.
Well, thank you, Blake. So Blake introduced me. I'm a public policy consultant here in DC. I'll sort of take you through the slides as they come up. And from time to time, I'm going to pause and ask Cheryl questions because I have a really good sense of the sort of the contours of the policy issues around bankruptcy, but I'm not a practitioner, and Cheryl is. And there will be certain points when it will probably be important for you all listening to have a sort of detailed practitioner's perspective on the nuts and bolts of the presentation. So I'm going to start with the first slide, SBRA. This was a statute that was signed by the president in August of 2019, but it had a staggered effective date, so it only became the law of the land in February. In short, it's a fast-track process for small businesses that declare bankruptcy, it's so new that people don't really know whether it's going to work or how it will work. I can tell you during the congressional debate about the SBRA, and this will come up in a later slide, the basic kind of deal that was cut is creditors had real concerns about SBRA because it cuts back on creditor rights, lender rights to such an extent, but the limitations on eligibility were set so low that it didn't seem like it would matter much. But if we go to the next slide, you can see that the transaction or the deal that creditors cut in Congress kind of got undone, because in the CARES Act that passed like a month ago or so, there was a temporary increase from the total debt you could have to be eligible for this new subchapter 5 fast track process from 2.7 million to 7.5 million on a temporary basis. The reason I bring that up to you is that we don't have hard numbers, the creditors don't, but 7.5 million should encompass almost all business bankruptcy cases, except for the mega cases that you read about in the papers, like Neiman Marcus files for bankruptcy. But almost all cases are going to be eligible for subchapter 5. To be eligible, you have to have right now you have to have debt less than 7.5 million. Half that debt has to come from your commercial or business activities, but that means the other half can be your personal debts. When a business wants to file for bankruptcy and Chapter 11, they have to affirmatively opt into subchapter 5, so it's not automatic. But the expectation is that almost all businesses that are eligible will opt in because it gives them kind of more leverage as the case proceeds. If I could see the next slide, please. I guess there are a couple of aspects we particularly wanted to call to your attention for those of you who are small business lenders. While management can be removed, as the slide indicates, for sort of fraud and incompetence and gross mismanagement, the expectation is that most of the time the existing managers are going to stay in place. That's not that different than a regular Chapter 11. But what was supposed to be a fast track process is some accelerated deadlines. So there's a mandatory conference in 60 days. The debtor has 90 days to file a plan. That's relatively quick for the bankruptcy process. Creditors cannot propose a competing plan for reorganization. But I think there have been some case law developments, some legal developments interpreting the statute, as new as it is, that I think Cheryl might want to talk about in terms of whether those deadlines are really going to be deadlines. And that presents, I think, issues for a lender that's trying to participate in a case. It's going to create some logistical complexity. I think AIS can probably help with that, but we want to talk a little bit about how the cases, the courts are beginning to interpret these deadlines in a way that Congress didn't really intend, but may well become the rule of the road. So Cheryl, do you have some comments on that?
Absolutely. The real concern is that there's nothing in the statute that doesn't permit and in fact encourages a debtor who is already in a chapter proceeding to convert to the small business bankruptcy. And in doing so, there have been cases already where debtors have been in Chapter 11 for as long as 15 months and suddenly converted to the small business bankruptcy, getting rid of the creditors committee with all the advantages of the no quarterly fees to U.S. trustees and the scary cut downs on the rights of creditors. They've also been converting from Chapter 13s. This means that the debtors actually had the advantage of all the delay tactics and feasibility of a Chapter 11, while then taking advantage of the 90-day time frame again to file their own exclusive debtors plan, as well as taking advantage of the maximum negative aspects for creditors, where the plan can be confirmed without any approval of creditors. Now, we're hoping that mandatory 60-day conference becomes a collaborative effort, and creditors should look at it in that respect and be aggressive about being part of a plan that is agreeable to all parties rather than one that is forced down their throat.
Thank you, Cheryl. And if we could have the next slide, I think it kind of hits on some of this point. The first is there will be a lot less information available to stakeholders in these small business cases. Normally in a business reorganization, there are disclosure statements that are filed. The courts explicitly don't think that's generally going to be the case. And as Cheryl mentioned earlier, again, a plan can be confirmed that seriously disables creditors, even if everyone objects and nobody votes for it. This is not the kind of Subchapter 5 is not the kind of bankruptcy process where creditors get to vote, unlike a typical regular business case. But I think the big change is, and I don't want to get too wonky in terms of bankruptcy talk, but there's something called the absolute priority rule. Basically says you can't keep an ownership in your business unless you pay all your creditors off or they agree otherwise. That is explicitly overruled in Subchapter 5, and that is considered a major, I know when this legislation was being drafted, that was a major point of contention, and it was this provision, this change that kind of got banking interests to agree to allow this to go forward, but only if the debt was set at 2.7 million. And now we're obviously in a different environment. I will say, as Cheryl said, the goal here was to sort of tilt the playing field in favor of the small business filing bankruptcy, with the goal of facilitating consensual reorganizations. And I do understand from my discussions with DOJ, that's one of their measures of how this is going to work. As I said earlier, it's only been a law since February. Nobody knows how it's going to work. But one of the ways the Justice Department is going to try and measure the effectiveness of this new provision is how often everybody kind of agrees and gets together and works something out. So if we could go to the next slide. So this first point on this slide is going to be familiar to those of you that support Chapter 13 cases for your banks already. This is kind of importing that concept of disposable income into the small business Chapter 11 context. But the next point on this slide is another biggie. This will allow, in Chapter 13 cases, as you all probably know, you can't reduce the value of a home mortgage to the value of the home or to the collateral. That's called anti-cram down by bankruptcy lawyers. The big change here is that small business debtors will be able to cram down or reduce the value owed to a mortgage creditor to the value of their home, even if it's just their personal home. You know, the idea also is that you can get a discharge a little earlier in these subchapter 5, Chapter 11 cases than you can in a typical Chapter 11 or Chapter 13 case. So those are some additional ways in which this new subchapter 5, which may cover very many cases in the coming months, will be unfriendly to creditors and will probably cause some needed process monitoring changes. Can we see the next slide, please? Okay, so how is subchapter 5 going to work? So like in Chapter 7 or Chapter 13, you guys are familiar, there will be a trustee. I can tell you the trustee selection process for subchapter 5 was different. Again, this all had to be done fairly quickly by the Justice Department. The Justice Department really put an emphasis on getting CPAs and accountants, less so on lawyers. The idea is, again, going back to Cheryl's point earlier, we want to facilitate consensual plans, and it may be that the skill set of a CPA or professional financial planner is better suited to that than I'm a lawyer who's really trained to argue with people. But in particular, they will have to examine proofs of claim, object to proofs of claim, oppose the debtor's discharge if the debtor's done something dishonest, provide information to parties in interest, and that means creditors here, and make a final report to the U.S. Trustee's Office. And I think the final report will be the sort of paper basis that the Justice Department uses to assess whether or not subchapter 5 is working. And then finally, they're supposed to appear at the 60-day status conference, kind of making them more a mediator than an advocate for any particular party. So can we see the next slide? This is just in a continuation of the subchapter 5 trustee duties. Before plans confirmed, they're going to accept payments, oppose the plan if they don't think it's feasible or if some rule has been violated. They are to deduct expenses. The trustee will get paid from some of this money, so keep that in mind in terms of figuring out your possible net return. If the management is removed, as I mentioned earlier, the debtor is, the subchapter 5 trustee will be in charge of running the business until they figure out whether it's going to liquidate or reorganize. And finally, as we've made mention to several times, they're supposed to try and facilitate a consensual plan, which means that everybody should be at the table and negotiate something that everybody can live with. And I just want to stop here. Cheryl, did you have any kind of practitioner comments that you wanted to insert in the last few slides?
Well, I think that it really is significant that this is supposed to be a consensual process, and that 60-day status conference is meant to be a time when creditors, debtor, and the trustee have an opportunity, a forced opportunity, a moment in time that's scheduled for them all to get together and work towards that consensual plan. I also think the home mortgage issue is a little different because, in fact, it's not if you purchase the home, it's not if it's a purchase money mortgage, it's not going to be able to be stripped down. This only occurs when is the typical situation where a small business debtor will take out a second on their home or refinance the home and use some of the funds to participate in the business or facilitate the business. So in that case, they will be able to strip down. Now, there's no limitation in the statute that says you can only strip down to the new value, but you have to have utilized funds for the purpose of facilitating the business growth. Discharge, as mentioned, is available when there has been substantial confirmation or substantial compliance with the plan, and after 3 years, and it's not, you don't have to wait till you are complete. So I think those are major issues, as well as as John said, I think the absolute loss of the absolute priority rule which has probably been the single greatest obstacle to confirmation of the plans in Chapter 11. Without that rule, and of course, if we don't stick to the 90 days, I think the creditors are going to have a great deal of input into requests for changes in the law, because that is a real stickler for them.
Right, and I think we'll have a slide on this later, but AIS has been monitoring Subchapter 5 filings to see. I think the expectation here in DC, but also I think if you read the financial press, at some point PPP loans are going to run out, unemployment's going to run out, and we're going to see a number of small businesses fail, and some of them will wind their way into the bankruptcy system. I think one of the reasons we just wanted to call your attention to this relatively new aspect of the law is that if everyone's expectations are correct, just as a practical logistical matter, each of you will, for your respective institutions, will be dealing with a very sort of almost hybrid system, a sort of a bankruptcy, a business bankruptcy, but looks a little bit more like a consumer bankruptcy process that's never been tested. And again, I would just indicate that probably you're going to need some process changes in order to monitor them correctly, and be heard at a 60-day conference if you want to. Again, the original deal sought in Congress was to make these changes that harm creditors and lenders, but make it applicable to so few cases that it wouldn't really impact the actual functioning of small business lending and collections. Having made the change that Congress made in the CARES Act, it's much more likely that almost all your small business customers, if they become insolvent and they file bankruptcy, will be opting into this subchapter 5 process. And it's so new, we can't really predict for you how it's going to work out, whether it's going to be consensual plans, whether there's going to be special delays built in because of judicial decisions, as Cheryl mentioned. But it's worth calling that to your attention. Can we go to the next slide, please? Now, the CARES Act also contains some straight up consumer law changes. These would be Chapter 7 and Chapter 13 changes. They are all temporary that were in the CARES Act. This mostly has to do with calculating a debtor's income for the means test, or whether in a Chapter 13 plan, whether debtor's income includes stimulus payments, that were doled out by Congress. And finally, it allows Chapter 13 debtors to modify an existing plan. So again, this is where some additional monitoring and attention will have to be paid if they can prove there was a material hardship caused by the pandemic. And it can extend payments for 7 years after an initial plan payment was due. Again, as this slide indicates, it's these are changes in law that are applicable for 1 year after the effective date of the CARES Act. I will tell you, though, it's worth noting that everybody in Congress expects to do a new CARES Act 2.0, and that was released 2 days ago in the House of Representatives, and there's a bunch more bankruptcy law changes proposed there. Those changes are not all temporary. The one I would call to your attention, which would be the biggest one that I anticipate Congress is going to fight about, is increasing, having a federal floor, allowing any debtor in bankruptcy to claim up to $100,000 in a home equity is exempt from creditors under the homestead exemption, and that is not a temporary change. I can't predict for you right now whether that's going to become law or not become law, but everybody on this webinar should just be aware there are additional consumer changes likely to happen, and some of them may not be temporary. Some of them will be temporary, or they'll be temporary because they want to exclude COVID-related payments from, the bankruptcy estate and things of that nature. But I just wanted to make sure everyone is aware of that particular change. There may be some changes related to home mortgages that if you'll support that part of your bank, allowing for extended payments out even after your Chapter 13 plan is finished. You can then make your makeup payments and still have the benefit of the automatic stay. So I just wanted to make people aware that could be coming. Can we go to the next slide, please? I guess one of the things, as I mentioned earlier, everyone is expecting an uptick in Subchapter 5 cases. I can tell you that the policy people in Congress and in the Justice Department are expecting this and trying to figure out, the courts are trying to figure out how to sort of beef up or staff up so that as particular states start to reopen, we see if we see a spike up in bankruptcy, the bankruptcies, the system can handle it. They're all looking at it, though, from the point of view of can the government agencies handle it. I think what you all have to think about is how do you handle inside your bank a spike up in consumer and small business cases. There's a very striking correlation between unemployment rates and bankruptcy filings. To date, we're actually down compared to last year, as this slide indicates. That is a bit of a head scratcher. Most of the people that we speak to indicate the courts may be closed in some places, that people don't want to file bankruptcy till they can meet with an attorney in person in places where there's a lockdown. That may not be possible, but I can tell you the courts and the U.S. trustee are preparing right now for a spike up sometime later in the summer. The big thing to watch, and can we go to the next slide, is depends on, and this chart just kind of illustrates the correlation that, if history holds, should show. I mean, you can see there's a relatively tight correlation here, and if unemployment stays as high as it is right now, again, if the historical pattern continues, this is great work by AIS. I don't think anybody else has this. If the historical pattern continues, we could see just a huge number of bankruptcies. There just seems to be some sort of delay. But what I was going to say is that when bankruptcy spike, when and if bankruptcy spike to this degree, as this chart would indicate they might, that can affect losses. I mean, that, if we could go to the next slide, that can affect the ability of banks to be able to absorb losses. It's one thing when you have customers where you've already, written off a debt, file bankruptcy. What to look for in a spike like this happened in the late 1990s, what to look for is a spike in filings that includes customers who were not already in default or weren't so far in default that you had to write the loan off under the FIFI Act standards. I think it's 180 days. So just something to watch. As you can see with this chart here, AIS is, again, I don't know anybody else is doing this, it's monitoring Subchapter 5 filings. A couple of days ago, middle of last week, there was a bit of a spike up in Subchapter 5 cases, but it seems to have kind of leveled off a little bit. I think the expectation is when the PPP loans kind of start to run out, we'll see a spike that may be, exponential, not linear, when the spike happens. So can we go to the next slide, please? As I mentioned earlier, one factor to watch is customers who are not behind filing for bankruptcy. There will be, I think, bank regulatory problems with how you are then going to have to assess the risk of your credit portfolios if a bunch of accounts that are not in default under the FIFI Act standards suddenly show up in bankruptcy. You have to wonder whether the bank regulators are going to come in and say you need to reassess how you underwrite or assess the risk of default for your loans. As I mentioned, the last point on this slide, the consumer groups in Congress are pushing for much more generous changes, and that is also going to the extent, logically and at a 10,000 foot level, to the extent that you make bankruptcy more financially attractive to people, you will drive up rates. And there are people who are, today making that argument, and they have an ear at least in one house of Congress. And so just sort of stay tuned. And Cheryl, do you have any comments on the sort of stats and the possible reason for the delay and in a spike?
Absolutely. I think, we've got with the CARES Act and with the funds being made available, we have a lot of forbearance issues that are going on. We also have just the basic lending community is being more generous in the way they're dealing with their client base because of COVID. There's been a lot of compassion, I think, exhibited. The result of that is that smart debtors with smart lawyers are using those time frames to buy time, because the bankruptcy game is really how much time can I get to catch up or figure out how I'm going to, make up my money in the end. So time is really the bankruptcy, is the essence of bankruptcy strategic play. And everybody is utilizing this time. And that's why I think, as we talk about what our, recovery will be, as the V versus the U, I think it's going to be the U, obviously, with a very, very long, straight bottom line, because people are going to utilize the time frame. The other thing is that I think there's going to be somewhat of a wait and see game. You've already mentioned the, the new potential legislation and arguments that are going onward regarding it. People are going to want to know, is that going to be a year that we have this benefit to punch in? Do we have to get in there within the next year? And, I can throw that back to you, John, and because, neither you nor I can say with any absolute certainty, but the chances, I think, of some extensions of those rights on the horizon, especially with new legislation, at least being put forth, there's a great chance that there's going to be some additional time lengths given to these rights, which will delay the onset for some debtors because they'll want to take advantage of more time.
Cheryl, I think that's right. I think, first of all, in the political process, I cannot imagine but that there's not going to be an effort to extend these one-year provisions when we get closer to expiration. I can't handicap whether that's going to happen or not, but it is more likely than not to be extended for some period of time. Now, with the both with the Subchapter 5 performance, we may have enough information to understand whether it's really harmful to creditors or not, whether it's really working or not. So there may be some arguments on the debt limit increase that we can push back on, but some of the stuff related to how long your Chapter 13 case can be and how many missed payments you can have before your case is dismissed, that's another thing that the House is debating right now. I think all of those are going to, those discussions are not just going to sort of stop after the summer, and we don't know what the sort of political landscape will look like in DC after November. It could be a very sort of debtor-friendly Congress, and so we could see a lot more of these kinds of changes being pushed. I guess with that, if we just go to the final concluding slide, I think that's the next slide. So I guess thanks for everyone's time and listening in. Just to sum up, the COVID public health emergency is likely to drive an increase in bankruptcy filings because of the economic dislocations. Most businesses that you lend to, if they become insolvent and go the bankruptcy route, are going to opt into Subchapter 5. Your rights are curtailed. You can have home mortgages modified. The laws will. The recent changes, impossible extension of the recent changes, is probably going to affect your losses and reduce your collections. And then again, AIS is, I'm pretty close to all of this here in DC in terms of following who knows what, who's really on top of the trends in the process. And AIS is really on top of their game in this regard. I mean, better than the federal government. I give their information to the federal government all the time because they ask. And so just kind of keep that in mind as you're figuring out how you might want to prepare for a potential spike in filings as they come up. And with that, I would conclude. Cheryl, if you have any concluding comments, otherwise I'd turn it back to Blake.
Just that I think the creditors are going to need to be extremely aggressive in their interaction with the Chapter 5 trustees, Subchapter 5 trustees, and be a voice and a collaborative partner, because making those relationships early on, as they're just beginning to operate with Subchapter 5, will, I think, bring long-term dividends in all respects.
John, sure. Thank you very much. It's been extremely informative. Brian, do we have any questions that we'd like to address right now? Or I know we're running a little bit over and I'm sensitive on people's time.
We do. First one says, as we learn more over the next 30 to 60 days, will AIS be working on predictive analytics or models?
Absolutely. So, since this started, we have been working with our clients on and our associates on what our plans are for scaling up for the volume. And so part of that is having a daily look at modeling where we believe this is going to go. We saw that the historical view of the data shows that strong correlation between the unemployment rate, the 90-day mortgage delinquency, and bankruptcy filings. What it doesn't show is, and you have the CBO estimate of what the unemployment rate is going to be. What it doesn't show is the potential impact of the stimulus or the deferral or forbearance programs. It also doesn't include a potential second wave of COVID-19 in the fall. So we're going to be working on modeling. There's a 5-month lag between change in unemployment rate and bankruptcy rate historically. So we're going to be overlaying these additional items and modeling. Be happy to provide that to all of our clients, as well as we compile every case that's filed in the U.S. Bankruptcy Court, and then we go to the docket of all open bankruptcy cases, and we update those, and then we database and put analytics against that. So we'll be able to get real-time information. And for our clients, AIS Law has put together a lot of focus and expertise around the subchapter 5. We've integrated that with all of our data systems. We'd be happy to give our clients the cases that impact them at no charge. So that's also going to be there. So yeah, Brian, we absolutely are compiling all of that and would be happy to send it to anybody on the presentation.
Okay, we have a couple more we can squeeze in. And then again, if anybody has any questions, you can submit them at the bottom with the Q&A. We'll be sure to address any that we don't cover today. So next question, do we feel that we will see a shift in the demographic of filers? For example, do we feel that we would see more filers choosing a Chapter 7 for debt liquidation versus 13s? Or do we feel that we could see a spike in more savvy filers who wouldn't have filed otherwise choosing Chapter 13?
Yeah, I can just go from a historical perspective and make a couple of comments. Historically, you see when these things spike, more 7s than 13s, or more growth in 7s than 13s. And the perception is that the restaurants and retail stores have been hit so hard that that's going to be a large population, a 5 population who want to continue to be in business, but need to remove a fair amount of their debt. So again, we'll be supplying those analytics in real time. And we'd be happy to share on whatever frequency through, access to AIS online, through Tableau reporting, or however, we can talk about how people would like to see that and how often they would like to consume it.
And this is John. If I could just add one thing. One of the provisions that's in the bill that was unveiled by the House Democrats yesterday was to raise pretty significantly the debt limitations for Chapter 13 filers. So it would raise it to $850,000 of unsecured debt and $2.6 million in secured debt. So that could make Chapter 13 attractive to sort of a slightly more well-to-do demographic. So I don't know if that's going to be enacted or not, but I just wanted y'all to know that and that's not a temporary change. That is one under contemplation.
Brian, do you want to ask one more question? That will probably, just out of sensitivity, I'm worried that we're running over. Absolutely. I'm assuming that AIS, can you share what your clients are expecting regarding volume spikes and how they're preparing to scale?
So it varies greatly. 50% in some areas and over 400% in others.
Okay, there was a second part. I said, are you aware of how they're preparing to scale?
Yeah, we've been working with our clients for the last 2 months, specifically on our ability to work with them in scaling within their institution as well as AIS. And fortunately, we've been building out software that creates a high level of automation, and then software robotics that does that. And so that's how we're working with our clients, which is, fortunately, computers work 24 hours a day and process things very accurately and very quickly. And then we're working on, from the associate side, the interaction model with our clients, so we can, again, address cycle time and volume. And we work 24 hours a day, 7 days a week. So that's what we've been working with our clients on. And then, Brian, if we can, we'll respond to the other questions through getting back with people, and we'll get all the information anyway. I really appreciate everybody who's attended today's session. And I think we've been asked to also get people together to talk about still in a video function, but in a peer group level on a round table to discuss scalability and other types of things, so we can have our clients talking together about how they're addressing those issues. So that's probably not going to be for 2 or 3 weeks, but we'll keep everybody apprised. Thank you again.